So, Gina, does the city get in a shred truck or anything? You know, like I've got all my old, budget notebooks and things like that.
Oh, yeah, we have trash. You can probably even bring them in here and probably can put them in the shred bin.
Okay, well, I'll do that when I get them all together and then.
Well, you bring it into City Hall, we have shredder there. We usually, if we have a mass amount of it, we bring it down here, throw in the shred bin, because they have Iron Mountain comes by and does like.
Well, that's what I was wondering.
I guess we're gonna fill up,
Yeah.
Yeah.
What is there, 3 or 4 of them, something like that?
Yeah.
Because I will have no use for them after December.
Yeah.
Hey, it's like origami now.
No. I'm not gonna make snowflakes out of it.
That's weird, but the computer would not be lining the stuff on. Oh. I'm going to hit it 6:57. I understand how the laptop could be on, so that they all link, Yeah. On the side there.
That might not go.
It's going.
Who's the mayor out of town?
No, he's there.
Oh, he's the mayor. Oh, okay.
I'm just kind of waiting for him to, pretty soon he's going to sit down. There was no proof 2 weeks ago.
He's long-winded.
I just want him to sign it. I want to stand there. Sign this real quick.
Candy Crush.
Yes. Thank you. It's already gone.
I've nailed that. Intro.
Here I am. And I didn't recognize you either. We were sitting next to each other, but good to see you.
Sorry, I am vaccinated.
Yeah, I am as well. I don't know.
Me too.
I don't know what the rules are anymore.
I don't either.
Our building today was designed that it wasn't no longer mandatory to wear vaccinated, but whatever. For now, we suffocate. Although I wonder if when we speak, if it's like in the court of law, it's going to remove it if you're actively participating. Yeah.
Because otherwise you do.
Oh, suffocating in it? Yeah, exactly. I know, but they said like a day or two and then it's gonna.
Chill that down.
Yeah, yeah.
90s and junior high. I don't. I'm right.
Yeah, all right. See you guys ready?
Yeah,
All right, the speaker should be on out here. You can. It's open public meetings. Yes.
Our best card.
We're not going to hold that one. We can bring some more chairs in if you would like.
Turn down all that.
Oh, I'm going to.
No, please. That would look silly for me to sit down with your standing.
I wasn't sure how many.
What a great three more chairs. Yeah, let's bring three more chairs.
I am vaccinated.
I am as well.
The families can sit together.
As well.
There you go. Take a seat.
We have like a vaccinated.
Yeah, you might want to walk through, but I think they showed me. Somebody showed me last night.
Yeah, it is.
Oh, perfect. I think I got it last. Now the actual, let me just pull it up real quick here. Good evening, everybody. Just give me just a few more moments here. Logistically. Councilmember Holland, Councilmember Grab, would you like to sit with the DS this evening? It's up to you. Your comfort level.
We could go back to our original seats.
Okay. Absolutely. I like it. And then it's up to you. Yeah.
Everybody move your knees, please.
I don't remember where it's at. Like down next to the one.
Okay, I'm gonna go around and just go. There we go.
I'm looking right here. You're still outside.
Yeah, I gotta run it. There, no, we can spread out a little bit more. So, we sit on top of each other. Recording. Okay. Yeah, no, I'm good, thanks. Oh, you
someday the mayor can join us.
Not now, he's still.
You guys like it when I'm down here getting the line.
This conference will now be recorded.
All right, good evening, everybody. It is July 7th, July 7th, June 1st. Apparently I still want to be on vacation. It's my first day back from vacation. June 1st, 2021 at 7 p.m., 7:07. This is a hearing for the City Council of Woodland. Pull up my sheet again here. It's this one over here. We have a number of folks in the gallery this evening. This evening, we're going to go ahead and take roll. And Mrs. Graham,
Yes,
you're here.
I am.
Yeah. Mr. Smith.
Here.
Mr. Fredericks.
Here.
I guess that's all that matters.
That's it, me too. The rest of us, we're out of here.
Mrs. Holland.
Present.
Mrs. Rounds.
Here.
Mr. Chapman.
Here.
Mr. Plaza.
Here.
Did I get everybody? Was that 7? I think that was 7. All right. Tonight, the time is now 7:08. We'll be going into a public hearing. Public hearing for the Belmont Loop Storage, LLC proposal to develop 3.69 acres into a full utility hookup RV park with an office building, showers, and laundry under a conditional use permit as approved by the City of Woodland hearing examiner. This is a closed record appeal. This evening, there's a process that we'll be going through, and I will read that to you now. First this evening, you'll be hearing from the examiner, a summary presentation which will last approximately 10 to 15 minutes. Second will be the appellant presentation for approximately 20 minutes, and then after that will be parties of record presentation for 3 minutes each, lists to be compiled, and applicant rebuttal for 20 minutes, and then council deliberation. So that will be the process this evening. I will be keeping time, but at this time I'm going to go ahead and turn this now over to Mr. Turner, our hearings examiner, and I'm going to share the screen here and make sure that we can do that. Yes. Mr. Turner, do you have control of the screen?
I think so. It's I'm looking. Something just appeared on my screen. I'm looking what it says. I'm going to go ahead and just try and share and see what happens.
Okay.
Wants me to open system preferences, and I'm concerned about that. I don't know what it's going to make it do.
Mr. Fredericks, can you make sure the volume's turned up all the way to please? Thank you.
I tell you what, I am going to skip the share screen option. I was just going to show a site plan so we could, an area map, but I think it's included in the record. Most people should be familiar with it. But good evening, my name is Joe Turner. I'm the city's hearings examiner. I'm also the author of the decision that's subject to this appeal. My purpose in this proceeding is to present the findings in my final order and respond to the issues raised in the appeal. I'm not defending the application or my final order. I'm merely attempting to provide sufficient background for the council to understand the application and the applicable code and how that relates to the issues raised in the appeal. My decision. The applicant's proposing, as you just noted, to operate a 67-space recreational vehicle or RV park on a 3.69 acre parcel located at 1860 and 1876 Belmont Loop in the C2 or Highway Commercial Zone. The site's bounded by Belmont Loop to the south, Old Pacific Highway to the north, and surrounding properties are also zoned C2 Highway Commercial and developed with various commercial uses, including Highline Homes to the northwest of this site, Kinderland Daycare to the northeast, Woodland Veterinary Hospital to the southwest, and Loss Prevention Group, Adair Homes, and Woodland Automotive to the west across Belmont Loop from the site. The applicant proposed to provide a RV we call it recreational vehicle park with 67 full hookup RV sites, an office building containing restrooms, showers, and laundry facilities near the northwest corner of this site near the entrance to Belmont Loop. A second building for restrooms in the northeastern portion of the site. 2 garbage and recycling enclosures, one near the northern restroom and one near the office. And roughly 32,000 square feet of common open space recreational area spread throughout the site, including a single 24,400 square foot or roughly half-acre area in the northwest corner of the site. The applicant also proposed an asphalt pad for a food cart or other non-permanent vendor on the east end of the site abutting Belmont Loop. RV parks are listed as a conditional use in the C2 zone. Woodland Municipal Code Section 1736-0303 allows recreational vehicle camper parks located east of Interstate 5 in the C2 zone, and this site is east of Interstate 5. The code provides that the conditional use process is intended for unusual or unique types of land uses which, due to their nature, require special consideration of their impact on the neighborhood and land uses in the vicinity. Such uses require additional review and permit approval procedures. In order to approve a conditional use permit, the city must find that it meets the approval criteria, which include: A, the proposed use will not be materially detrimental to the public welfare or injurious to the property or improvements in the vicinity of the proposed use, or in the district in which the subject property is situated. B, the proposed use shall meet or exceed the performance standards that are required in the district in which the subject property is situated, in this case the C2 zone. The performance standards are standards regulating such things as setbacks, building height and design, parking, landscaping, etc. Subsection C requires that the proposed development shall be compatible generally with the surrounding land uses in terms of traffic and pedestrian circulation, building, and site design. Subsection D requires that the proposed use shall be in keeping with the goals and policies of the Woodland Comprehensive Plan. And subsection E requires that all measures have been taken to minimize the possible adverse impacts which the proposed use may have on the area in which it is located. So in order to approve the application, I had to find that the proposed use is not materially detrimental or injurious to the public, meets or exceeds the performance standards for the C2 district, is generally compatible with the surrounding land use in terms of traffic and pedestrian circulation, building, and siting design, that it's in keeping with the goals and policies of the comprehensive plan, and that all measures have been taken to minimize possible adverse impacts. I determined, based on the findings in the final order, that the use proposed in this application complies with all of these approval criteria, subject to the conditions of approval in the final order. The appellants argue in the appeal that the proposed use is materially detrimental, that it will result in increased crime, drug use, and homeless population. But they didn't provide any evidence to support those concerns. The applicant bears the burden of proof that the application complies with all of the applicable approval criteria. But the applicant is not required to disprove all unsupported or speculative concerns about the potential impacts of the use. Any use on this site will attract additional people to the area, which will likely result in a proportionate increase in criminal activities. But there's no evidence that the specific use proposed in this case will cause a disproportionate increase in crime greater than other potential commercial uses for this site. In finding that it would not have the cited impacts, I relied on the statement from the Woodland Police Chief that the only other RV park in the city has not generated any significant increase in call volume or criminal activity there. The appeal argues that the final order misquotes the chief. The quote is taken from Chief Jim Kelly's email dated March 23rd, 2021, which says, quote, "The city has one RV park in the city limits, and there does not seem to be any significant increase in call volume or criminal activity there," end quote. The appellants also argue that the use will reduce the value of surrounding properties. The appellants cite to a section of the code that requires protection, but argue that the code requires the protection of the neighborhoods, residents, property owners, and businesses of the city. I believe they are correct in that. But the plain language of the code doesn't require consideration of property value impacts alone, apart from other materially detrimental impacts. So if this or any other conditional use were to have materially detrimental impacts, that would impact property values. But the code doesn't require consideration of property values separately from such impacts. The Court of Appeals in Washington, in Department of Corrections versus Kennewick, concluded that property value impacts may occur in the absence of any materially detrimental impacts, i.e. due to perceptions about the type of use proposed, but not the reality. And the court held that such concerns that the use will generate adverse impacts that do not actually occur are not an adequate basis for denial. In this case, the final order imposed conditions of approval regulating the use and activities on the site and to try and ensure that the issues raised by the appellants don't occur. Those conditions include limiting the duration of stay consistent with the code, providing explicit objective limitations on returns, and requiring that the operator report to the city, provide documentation to the city on a quarterly basis that demonstrating compliance with the duration of stay limitation. The code prohibits occupancy of more than 90 consecutive days and prohibits returns within an unspecified time. The conditions of approval for this application have more specificity about how the 90 days is measured and when people can return. The conditions also require that the applicant adopt and comply with conditions, covenants, and restrictions, or CC&Rs, that, among other things, prohibit vehicle repair on the site, require that RV sites be maintained, that they be kept in a clean, neat, and tidy manner in a good repair, and also limiting the ages of the RVs allowed on the site. RVs older than 10 years old are generally not allowed unless they're in good condition and working order. I admit that's a subjective standard that does give the operator some limited discretion, but it allows older, nicer RVs to be on the site. Gives some flexibility there. The appellants assert that the city can't enforce CC&Rs. That is generally true. They are private agreements, but in this case, compliance with the CC&Rs and the CC&Rs themselves are expressly included as conditions of approval for this application, and they're listed in the conditions. Therefore, in this case, the city can require compliance with the CC&Rs just like they could with any other condition of approval. The uses and activities on the site are also subject to a variety of code provisions that affect the appearance of the site and activities occurring thereon, including property maintenance requirements of Section 1404-100 of the Code, the health and sanitation standards of Chapter 8, the landscape maintenance requirements of Section 1746-125I, and the public peace, morals, and welfare standards of Chapter 9. In addition, Section 1772-090C requires an annual review by the city to ensure proper compliance with all permit conditions, and that is required as a condition of approval. The appellants assert that the examiner erred in assuming the city will enforce compliance with the conditions of approval. They assert that this is an erroneous assumption because there is no permanent code enforcement officer for the city. But I understand that the enforcement duties have been assigned to other staff, so enforcement is still occurring. There's just no designated enforcement officer. I don't believe that the city could deny this application based on assumptions that the applicant will not comply with the conditions of approval, or that the city will not enforce such compliance. If, as the neighbors assert, there is no enforcement in the city, then the applicant can simply begin operating from the site without any prior approval. The appellants also assert that the city's only remedy in the event of a violation is a maximum fine of $1,500 per month, which is consistent with the $50 per day maximum fine allowed by 1788-050. However, the code also expressly authorizes revocation of the conditional use permit if the city determines that the applicant is not complying with the conditions of approval. Section 1772-090C of the code provides for annual review of conditional use permits in order to ensure the operator is complying with the conditions As I noted, that is expressly required as a condition of approval for this permit. This section also provides for revocation of the conditional use permit if the permittee is found to be in violation of the permit conditions, either by the planning director or the hearings examiner. The conditional use permit approval runs with the land, so any future owners of the site will also be bound by these conditions of approval and subject to that revocation requirement necessary. So I concluded that this use as proposed and conditioned will not be materially detrimental or injurious to the public, so that standard is, I determined that that standard was met.
3 minutes, Mr. Turner. You have 3 minutes.
I'm sorry?
You have 3 minutes.
Thank you. Thank you, sir. Criterion B requires that the use meet or exceed the performance standards of the C2 district. I concluded that those were met regarding the dimensional design, parking, and other standards as set out in my report. Subsection C requires that the development be compatible with the surrounding land uses in terms of traffic and pedestrian circulation, building and siting design. The plain language of the code limits that compatibility requirement to those physical aspects listed in that section: traffic, pedestrian circulation, building and siting design. It doesn't require a finding that the type of use proposed is be compatible with existing businesses in the area. The code does not require consideration of synergy, vibrancy, or the highest and best use of the site, and those were terms used in the appeal. The code doesn't use those terms, and it expressly limits the compatibility requirements to the listed physical standards. Subsection D requires a finding that the proposed use be in keeping with the goals and policies of the comp plan. I addressed the findings that I believe were I addressed the comprehensive plan policy that I believe applied to this application. Under that section, the appellants assert that the use will not increase the diversity of commercial services in the area. I assume that's related to comp plan goal EC1, which provides, quote, support a diverse and balanced local economy to ensure sustained growth, locally available commercial services, and varied employment opportunities. I concluded that this use will increase diversity by providing a commercial service, an RV park, that's not currently available in the area, and therefore the application is consistent with that policy. And the appeal didn't challenge other findings regarding any other comprehensive plan policies. And as conditioned, I concluded that all measures have been taken to minimize the possible adverse impacts of the use. Other appeal issues that were raised, the appellants argue that the final order erred in not requiring compliance with purpose statements, but they failed to identify any error. But the courts have held that the general goals set out in purpose statements are implemented through compliance with the specific requirements of the approval criteria. Specific zoning laws control over the general purpose statements. And although purpose statements may be relied on to guide the interpretation of ambiguous criteria, applicants are generally not required to demonstrate compliance with the general goals and policies set out therein. At the hearing, the opponent cited the purpose statement in 1736-130A5, the architectural and site design standards, which states that the purpose of those standards is to protect and enhance business environment and property values within the city in manners that support and stimulate business and industry, and also promote desirability of investment and occupancy business and other properties. That is clearly a purpose statement. It doesn't contain any language that could be construed as an approval criteria that requires specific actions by the applicant.
Mr. Turner, your time is up.
Thank you, sir.
All right, thank you. Mr. Nigro, are you speaking on behalf of the group this
I
evening?
believe David Duncan, our attorney, is going to start.
Okay, he's on the line here?
Yes.
All right, Mr. Duncan? Can you hear me okay?
David Duncan is here, Sam Nigro and Jay Dawson, I believe, are present in person. I believe that was Travis who had a comment.
No, go ahead.
All right, Mr. Duncan, I'll provide you 20 minutes.
Okay, the core of our presentation will be from Mr. Nigro in person. We have submitted for the record our appeal. I'm not going to rehash that since it's already on the record, but the core of our appeal is based on a number of public welfare arguments that, as well as the the errant interpretation of the code sections or the evidence presented thus far in the application. For starters, the chief of police, we believe, was taken out of context. His statement was in response to a very broad and hypothetical question. It was not very specific to this particular situation. And in a time with crime rates rapidly increasing across the nation, including on the West Coast, as well as the stretched resources of the city, the ability of the city to properly maintain and enforce the increased burden on the public welfare is going to be dramatic. The other arguments of center around compatibility and the appropriateness of this facility in a commercial zone. You listed off several of the neighboring businesses, and an RV park fits into a commercial district about as well as a parking lot versus a campground. So with that, Mr. Nigro will take over and present the main thrust of our presentation.
Thank you, Mr. Duncan. Mr. Nigro, if I can get you to just speak up just a little bit, just so the folks they have a hard time hearing from.
Sure. Can you hear me there?
Yeah.
Okay. Hello, ladies and gentlemen. Well, my job here is to prove that this RV park is going to be materially detrimental to the neighborhood and to Woodland and to our business park. And I'm going to speak specifically to the impacts, and I'm going to address a number of the issues, and we brought some other colleagues and neighbors and business owners and property owners from Belmont Loop along here, and we're going to cede some of our time, if it allows, to them to speak. I may also request, as time goes on, that we ask for a few more minutes to do that. So, Melissa with the City of Woodland's Planning Department, and this is addressing appeal issue number 1, the misinterpretation of the police chief's comments. Melissa with the City of Woodland's Police Department queried Police Chief Kelly, and she asked, is there a more increase in crime now as when before the park went in, referring to Lewis River Trailer Park? Does crime increase in summer months at the RV park? The police chief writes that there doesn't seem to be an increase in crime. The police chief was not able to give data to support his claim, and he has been in Woodland for only 3 years. The examiner then said in his findings, there is no increase in crime. The examiner misquoted the police chief in this, so I encourage you to find that the hearing examiner erred in that he misquoted the police chief and gave no data to support his claim of no increased crime. I'm going to speak specifically again about appeal issue number 2, which is married up with 6 somewhat, that the city's ability to perform code enforcement and its ability to apply a very good visual and mechanically standard to RVs in the park. The RV trailer park developers state they will only allow trailers and RVs newer than 10 years old into the park, or any RV that's in good working order, clean, and well-maintained in appearance, as to be determined by the manager of the park, which is darn ambiguous. How can this rule be pragmatically enforced by the city? It can't. Also, can the City of Woodland afford a code enforcement officer, as we don't have one? And it was mentioned that, well, those duties were given to others. I think if we queried those others to ask how much those duties how much code enforcement duties they're actually able to perform, I believe you will find that it's minimal as compared to what's necessary. How effective will this enforcement be? The trailer park can simply pay a $1,500 per month fine, also known as a non-compliance tax, and never, ever have to follow code. The examiner erred in finding that Woodland can effectively enforce CC&Rs and codes. Appeal issue number 4, non-compatibility with neighborhood. A commonly used phrase in community development when assessing compatibility is that all neighborhoods should expect change, and we do, but no neighborhood should expect to endure radical change. Building an RV trailer park in the Belmont Loop Business Park is exactly that. It is radical change for not only our businesses, but also for the entire city of Woodland. The businesses and property owners of Belmont Loop are in agreement. This radical change will negatively and permanently affect our lives, our businesses, our livelihoods, and Woodland as a whole. As for my wife, Sherry, and I, we've already been given written notice that our tenant at 1930 Belmont Loop, which is AK Accounting, will not be renewing their lease if this trailer park is allowed. That's an impact. They have over 150 clients that frequent their offices. They've been a good tenant of ours for a number of years. Gretchen Sass of Contact Wellness told me just today, and she's been here 20 years in business. She said that they're not intending on renewing the business lease if the RV park is allowed. These businesses do not want to deal with the myriad of issues that a 130-plus transient person RV trailer park within an actual business park will bring. You need only look at Portland and Delta Park to see the results of this, even with supposed CC&Rs. My wife and I own 2 office buildings on Belmont Loop. We operate 2 businesses out of 1, and we employ 10 people. We recently purchased a 3rd lot on Belmont Loop with the intention to build. As proof, here are the plans. I've spent well over $100,000 on this project thus far. If this trailer park is allowed, I no longer have enough faith that this project is viable, and I will be canceling the building. I'm much likely better off, as are the other businesses on Belmont Loop, to relocate and or build in Ridgefield or Kalama. Nick Sullivan, who happens to be here as well, who owns Field Instrument Controls as an office on Belmont Loop. He's recently purchased 2 acres on Belmont Loop and was intending on building an office as well there. And he can speak on that, but he informed me that he's not going to do that if this, in fact, the RV park comes in. To be quite transparent, we might be better off developing our vacant lots for trailers too, or maybe even simply asphalt them in, have occasional campers and trailers stay there. If we can't beat them, heck, we just as well join them. Ladies and gentlemen, believe me, none of us want Woodland to be known as RV and Trailer Park Central. We want smart growth, we want a safe town that our children can be proud of, and we want growth that benefits Woodland's future. We ask that you find the examiner wholeheartedly failed in his finding that the RV trailer park is compatible with our business park for C2 development, which is absolutely not. Appeal issue number 5. The examiner's reluctance to apply the applicability statement to interpret comprehensive goals and policies in context with the neighbor's arguments. The purpose of highway commercial zoning is clearly laid out in the purpose statement of the Woodland Municipal Code. For reference, this code is 17.36.010. It states development will complement and not adversely compete with other commercial use. All of the property on Belmont Loop is Zone C2 or highway commercial. The allowable use for this C2 zone is extensively listed in the code. Developers that are planning other uses must apply and be approved for a conditional use permit. This process that we're going through right now is needed, as these would be conditional uses that are naturally outside of the standard C2 uses, and as such may likely not complement and indeed adversely compete with the C2 intended use. The permitting process is specifically to protect the people of Woodland from development that can be ruinous to business, neighborhoods, townspeople, and our city, but profitable to the developer. The examiner failed to take into consideration the negative impacts that this transient RV trailer park will have on our city. They will be saddling Woodland with a permanent transient RV park for motorhomes and for trailers. The examiner erred in his proposed RV trailer park does not complement other businesses in the area. If we believe that the definitions in this code are ambiguous, we can then fall back and review the 20-year comprehensive plan. The comprehensive plan states that Woodland wants successful businesses that provide robust jobs for residents, economic growth, as well as good business community that is engaged with the city. Admittedly, our current code perhaps doesn't get us there, and this is ridiculous. We have the potential for a robust economic future. The developers have penned a feel-good statement of how they want to play well with us neighbors and us business owners. This in no way speaks to Woodland's long-range economic goals. It's as if they're saying it's going to be a damn good-looking trailer park and shed, and now we've all done what's necessary and crossed the T's and dotted the I's. That's not good enough. If the city of Woodland decided to deny a 150-room retirement residence in town because it did not fit the character of the neighborhood, then a decision against the trailer park in a business park must be deemed also not to be a vision of the community as per the comprehensive plan. And lastly, this RV trailer park will take up 3+ acres and will employ 1 to 3 people. Maybe a husband and wife who will likely get their trailer space for free as compensation, perhaps even a modicum of pay. This is not even near the suggested expectation of 20 jobs per acre that the comprehensive plan outlines for C2 development. It's incredulous for the developers to state that they will simply add space for food trucks and this is going to create jobs. The trailer park will not only be a great liability regarding criminal, financial, and property values, but this trailer park will be a drain on the city's services. Imagine 67 trailers, all packed into 3 acres. The only measurable real estate tax collected will be on a tiny 850 square foot structure that is to be built for bathrooms, showers, and an office. All of this on an entirety of 3 acres of prime woodland commercial real estate. Essentially, there will be 67 mobile RVs and trailers with the same frequency of need, and arguably a lot more, for police response, domestic violence response, fire response, medical emergency calls, as would be created by a neighborhood of 67 homes. All of this while being tax-free, only one 800 square foot building. Quite frankly, as a businessman, I absolutely get it. I'm a developer as well. I would never think of doing anything like this. It's an amazing business plan. Build one small building, lay some asphalt, pay little to no property tax, employ the fewest of people, and by their own admission, collect $700 to $800 per space at full occupancy. That's $46,000 to $53,000 per month. It's brilliant, but it comes at a huge price. It comes at the price of the financial, safety, and well-being, and let me back that up here. It comes at a huge price. Its financial, safety, and well-being impacts to our collective businesses, our townspeople, and our city. This is an atrocious plan for our city who's doing great things. If this large transient RV trailer park is allowed, it will change the character of Woodland forever. Please do not allow this to be done to our city. And I'm going to cede this to Jay Dawson, if I may. How many minutes do we have?
7.5.
Okay.
I'll be quick. Hi, everybody. I'm Jay Dawson. I've been a business owner and property owner at Belmont Loop since it started. I think this project is so misguided in what it's going to do to all of us business owners down there. It's going to have a negative impact for all of us. And I just want to express my concerns as to your approval of this, because once they're in there, even if they're not following the codes and keeping up the CC&Rs, they're never going away. They will never be gone. And it's all of us that's going to pay the price. And I would ask you, would you want to have this next to your business or your home? Just consider that when you're making your decision, because that's where we are. That's my retirement. And someone's going to come in and just snatch it and take the value of our businesses and hammer them. So please consider carefully. Thank you.
Mr. Nelson. Anyone else, Mr. Niagara?
Hello, I'm Nick Sullivan from Field Instruments and Controls. I have a family-owned company. We employ 16 people. We have plans to more than double that over the next 8 years. I currently have a beautiful building in Spokane and a warehouse in Spokane. and I'm leaving it all, and I'm leaving it for all the concerns that everybody here has. Let me give you a few examples. I have women that show up in my office in the mornings, and they don't know what they're going to walk into. There's people that sleep in our front entryway. There's people that sleep in our back patio area. There's people that bang on our windows in the middle of the daytime. There's people that break our windows, climb over the fences. They shower in our back patios in the middle of the day while people are inside the building. They've set the building on fire. They've gone inside the building and ate pizza and cookies, forgot they set the building on fire. They call the police. The police come out and arrest them. That's the only time the police have ever been there. Out of all those other times when we call the police in Spokane, they can't do anything about it. So when I hear about code enforcement, when we have people banging on windows, leaving trash in my office parking lot, and the police don't even come to that, where's the code enforcement for that? So listen to our concerns. These are real, valid concerns. The reason I wanted to move to Woodland is to get away from that stuff in Spokane. If this goes through, I'm not building that office here. I will go somewhere else because it does not fit my vision. Thank you.
Mayor, just a comment.
Mr. Randolph.
Your mic. I'm good.
Okay.
You request more time? Yeah. So I think we need to request more time right
Nope, you're still good.
Okay. Hi, my name is Kim Brennan. I own Kinderland. It's the child care center that's next to the proposed RV park. We've been there for 16 years. Very concerned about this. If allowed, this project will have a significantly negative effect on both the actual and perceived safety of the children in our care. This will create a reality in which our center and playground will constantly be surrounded by people who are unknown to us. Because their presence in Woodland is, as required by the proposed RV park rules, limited 90 days or less, any transient customers at the park who are registered sex offenders will not be registered in Woodland and will not be known to us or the Woodland Police Department. I have absolutely no doubt that I can restructure our environment and program to keep our kids safe when surrounded by transient strangers. I've operated a child care center in downtown Longview for 20 years. I know what is involved in running a child care center in an area surrounded by transient strangers. I'll need to hire additional staff so that when we have kids on the playground, we'll have teachers who can look outside and see what's going on around us, not just seeing what's happening with the kids on our playground. We'll need to build a taller fence to ensure additional privacy and to make it more difficult for things to inadvertently or purposely get thrown over our fence. We will need to choose a fencing material that can't be seen through, as we will otherwise be unable to control what the children are visually exposed to from the RV park, where behavior could be dramatically different from behavior at traditional businesses sites, since the patrons of the park will be, for all intents and purposes, at home, in their living room, in their backyard, and they won't have the controls, societal controls of being out in public. We will need to be prepared to exit the playground immediately if there are things that are occurring, such as inappropriate language, fights, etc., that could be harmful or frightening for the children in our care. So while I know that I can keep kids safe if this is allowed to go through, it will be a tremendous financial burden to implement the necessary changes. Kinderland is fortunate to have an excellent working relationship with the Longview Police Department. We call them all the time. We call them when we see somebody that we don't recognize. We call somebody when there's somebody sleeping in the alley. We call them when there's somebody sitting in a car looking through our playground fence. On average, probably 2 or 3 times a week we call them. If this project's allowed, we'll be calling the Woodland Police Department every time we see someone we don't recognize showing interest in our facility or our children. Whether they're just lurking or whether the individual is appearing to watch our children, we have to assume that everyone is a threat and will thus need to have the Woodland Police Department check that they and their intentions are safe. Thank you for your time.
If I could just make an objection.
Go ahead, please.
Well, I'd like to put an objection on the record that any testimony outside the written appeal be struck from the record, because of course we've agreed ahead of time. That was the way that this hearing would be handled, and that's pursuant to the laws and the code, Woodland municipal code that limits the testimony tonight to that presented in the written record within 14 days of Mr. Turner's decision.
David, do you have any response to that objection?
I'm sorry, I did not hear the objection. It was very muffled. Can we repeat it?
If you could, after the mic, please.
Yes, please do.
Sorry, Mr. Duncan, I know this is an awkward setting here. I made an objection on the record that most recent testimony and anything not included within the scope of the written appeal be struck from the record and not considered by the council here today pursuant to the Woodland Municipal Code appeal section, which requires that the issues on appeal be limited to that's within the written record presented.
Mr. Duncan?
Again, I had trouble hearing, but I believe the objection was to some of the recent testimony was not part of the original appellate or within the original jurisdiction. The broad scope of our appeal and the numerous issues that we raised for the compatibility, the public interest, the public welfare, all of the submissions and the statements this evening spoke and addressed to those points, so I think they are admissible.
And I will sustain the objection, Mayor. I mean, basically, the parties have agreed on time limits, and in addition, it is limited to the record. And the reference is what's happened is this is a closed hearing, and basically the testimony that was presented at the hearing before the examiner is as far as it can go. And furthermore, it's limited to the categories which they stated. But this is going outside of the record, and so I will sustain the objection.
Okay.
Could you clarify what's outside the record? I mean, what is it?
Outside the record is we are limited to the testimony that was presented before the hearing examiner. What we're doing right now is we're redoing that, and that's not the purpose of this appeal. So if you are saying what was said back for the hearing examiner, that's okay. To the extent that you go out of it, to the extent that it's not in the record, you can't do that.
I understand that part. My question is, what have we gone outside of
Well, first of all, the other thing is we had someone testify who was not a party of record, and that also is not.
But it's my understanding, though, that can't we see our time if we're allowed 20 minutes? May we not?
No, this is a closed record. This is not a rehearing. So you are limited to what was said. If you wish to say points that you made at the hearing, you could. But this is basically the hearing examiner, the evidence heard. So you are limited to that record.
Forgive me. You are?
I am Frank Randolph. I am the city attorney. I attended the meeting on...
No, I'm not. I don't even need to do your item.
And I attended the meeting on the 25th where this was discussed and agreed between the attorneys. So I am sustaining the objection.
So the only thing, so Sam's testimony and my testimony, they're the only two that we can use today?
Well, I mean, to the extent that it's in the record, that's correct. But we've gone past that, and that's not what the purpose is to hear. This is a closed hearing on the record that the city council has to rely on.
Well, sir, even though, you know, in what I submitted, I had the names of the individuals that, as a group, we were going, what we're bringing forward to. Not just me, not just Jay, but as a group, we're bringing this forward because we all have specific issues. And pragmatically, we all own property. We're concerned about the children. You may think there's some decorum in this, and there might be, but it doesn't make sense. Because we're the city of Woodland. We're just trying to make sure that this fits.
I am applying the law. Let me ask, Mr. Turner, are we getting outside of the record that was presented before you, or are we still within?
As far as who appeared at the hearing, I don't recall. I don't have the list in front of me. But most of the testimony, then, the issues that I heard sound like they were raised at the hearing. So I think the majority of the testimony was presented at the hearing before me. But as far as who testified, who's a party of record, I don't recall.
Okay, well, then I will refer to Rachel.
Sorry, I'm kind of back and forth. And I'd like to clarify, and I don't want this to, of course it's going to become contentious because that's how these things go. But in answer to the question, of course there's decorum because this is a legal process, and should it go any further, it's going to be in a court of law that conducts a de novo review, which is based on the record. So there is decorum here, unfortunately. And although it would be important to hear what everybody has to say again, according to the Woodland Municipal Code, which is what guides this proceeding, we are limited to those 5 or 6 points points of appeal that were submitted. So to the extent that anybody else had issues with the decisions that were made, they had an obligation to put those in writing and submit those within 14 days of the decision. So we don't have the ability to come here today and rehash the entire record that was submitted last time, despite the fact that those are real concerns, and we hear those concerns. Those aren't on appeal. The 5 issues on appeal are in writing, and to the extent the testimony is given tonight, it should be on those 5 points, because that's what the law requires.
Okay, can I ask that one question? I still don't understand what part of our testimony you're objecting to. Is it mine, is it his, is it hers?
Yeah, I wasn't objecting, sorry, and I'm staying close to the microphone, I don't know if that connects to, yeah. I'm not objecting to the testimony of the people of record who were referencing the 5 points made on appeal. What I'm referencing now is the people that are showing up that are not named in the record of appeal and who are not responding to the 5 points on appeal, which is what the process requires here today. Okay. And your attorney, I believe you were represented by David Duncan. Mr. Duncan was in a meeting on the 25th as required by the Woodland Municipal Code, where we were required with Mr. Goddard to outline the issues on appeal, and that's what we did. So that's how an appeal works. It's not a second opportunity to come back and say everything that was said the first time. It's an opportunity to appeal specific issues that are taken with the hearing examiner's findings, and that's what we're supposed to be here for tonight.
No, wait, this is a here, no, wait, Mr. Duncan, do you have a reply?
Mr. Duncan, do you have a reply?
Again, the statements brought forth by my clients are relevant. I would agree with Mr. Turner regarding that. As far as I don't believe I received a final list of submissions or of the names of people who probably followed the protocols to submit a second intent to appear. So I can't speak to that other than I would urge the council to hear the voice of the public.
May I? I think we should concede to the fact that we need to stick to these line items. I think we're all in agreement with that. But we all need to have a voice to talk about those line items.
And we will stick to the time limits agreed by the attorneys.
Unless I ask for more.
That was, no.
May we ask for more? Was that okay, Will?
That was the
Mr.
purpose
Finn?
of the meeting on the 25th, was to agree to a schedule, which everyone did. We're not going to ad hoc this, and I agree. This will go up to the Cowlitz County Superior Court. We will have the record, and you will just have to repeat it there. Because I think it's a valid concern. It was agreed to the parties. We had the opportunity to discuss it. You were not there to speak these things.
We had 24-hour notice, sir.
And we will stick with the rules that were agreed upon. That is my recommendation.
We had 24-hour notice, less than 20. Oh, the meeting's tomorrow. I'm in California. You know, when was there time to mention it to anybody? There was not.
In accordance with Woodland.
Yeah, whatever.
Yeah, but that was...
It's in accordance with Woodland Municipal Code, which is what we will follow tonight.
So
Mr. Goddard has just informed me that everyone that has spoken tonight is a party of record.
Okay.
So anyone that has provided testimony is a member of party of record.
We still have time.
Still have 10 minutes, yes. So
I'm sorry about the time, and our understanding was that we could ask for more. We didn't know that we couldn't. You know, if they told us that,
How were they parties of record? Because they filed letters, they sent letters in earlier, correct? Okay, well, there's a myriad of people who sent letters that are, if that's the case.
So the 20 minutes, let me go back to we still have about 1 minute and 45 seconds left on the 20 minutes, but let me go back to, and this is the appellant's presentation. So parties of record will have 3 minutes each after that 20 minutes. Right. So you still have a minute and 45 seconds left to go for the appellate presentation if there's more.
Would you care to get up and have a few?
And I'm
business over there, and now it's going to impact you now.
I'm going to start the time now.
So can I just...
Does anybody else want to stand up? Bobby?
Mr. Randolph?
Mr. Fredericks.
I don't recall her name. Legal counsel back there.
Sorry, my name is Rachel Goldfarb.
Ms. Goldfarb, are you comfortable with the fact that everybody's on the record here? I just want to...
Yeah, quite honestly, I'm having a hard time following who's on the record because I do have the notice of appeal here, and it has the names of a number of individuals, not all of whom are speaking here tonight. So while I understand that there was a record created in the underlying action, and those people may have spoken there, my understanding of the Woodland Municipal Code's process is that there must be a notice of appeal filed by those parties, and then a notice of intent submitted at least 5 working days prior to the hearing, indicating that person will speak. So I don't have, I see a list of folks here. I do believe Mr. Dawson, Mr. Nigro, did I say that correctly? Obviously are on that list. As to the rest of these folks, I'm not sure that they're on the list. Okay.
Everybody's spoken.
Okay. Does that answer your question? I'm not.
It does. I just want to make sure we're consistent here with what we've allowed, and if there's anything that should be stricken from the record, we should obviously be made aware of what should be stricken, if anything.
And what we have is Mr. Turner saying that what was discussed so far was the evidence that was presented in the trial. We still have the agreement of the parties, 20 minutes is just about up, and that we also agreed that each party of the record has 3 minutes to also speak, but again, limited to what was presented at the hearing.
Just to be clear, party of record would be any individual noted on page 1 of this document, which is part of the appeal.
That was my understanding. And then I believe that there were 2 letters submitted in time with the notice of intent, which was Dr. Solitzer. Hopefully I'm saying that correctly. I'm not sure if he's here tonight.
I believe he is online here.
Okay. And I believe a Mr. Sapp, that he said he would not be attending, and Carol and Daniel Ketchum are the 3 individuals who submitted a notice of intent in addition to the individuals identified in the appeal.
Thank you, Ms. Goldfarb.
And with regards to what it was I was asking to be stricken, it was the last bit of testimony. I'm not sure if that individual was on the notice of appeal, but that testimony did appear to go outside of the notice of appeal on those issues, so that's what I was referencing.
Mr. Nigro?
I think we're finished, other than, there may be a few people who want their 3 minutes that are matter of record.
Okay.
No.
Okay. So we'll go ahead and move on to the next portion of the agreement here for parties of record. 3 minutes each, and how many, can I just see a show of hands of how many will be speaking? Okay.
I'm also here on the call. My name is Dr. Jeff Blitzer. Yes.
Okay, thank you. We'll take the folks in the gallery first. Okay.
Sure.
Ma'am? If you could please state your name as well.
Yes.
So we know who we're speaking with, and you'll have 3 minutes.
My name is Mary Goebel. I am the office manager at Woodland Veterinary Hospital, and I am speaking tonight on behalf of our business owner, Dr. Brett Sharman, who built our veterinary hospital there 6 years ago. Had we known that this was possible, he would not have chosen Belmont Loop as the location for our veterinary hospital. As it stands right now, and it's our problem to deal with should this go through, but one of our rooms that is right at the corner of our lot, that is where the entrance to the RV park will be, is at this point known as our comfort room. So we then have to find a different way to help those clients so that they're not having to exit a room after having to deal with the end of a life of a pet while staring at RVs and people waiting to check in for their stay at the RV park. There is no way to know whether this is really going to be a travel RV park or whether this is going to be, a temporary / permanent living residence for all of these RVers. There's definitely a difference between RV parks that are Good Sam or KOA versus just your standard RV park. I know that myself from having traveled with an RV. Speaking to the compatibility with the businesses down there, there is nothing on Belmont Loop for RVers to access other than Popeyes and the Chevron. The chiropractic office has a 2-month waiting period for an appointment for chiropractic visits. We are not accepting new clients. Most don't go for music lessons or for driving lessons or for loss prevention at a business. There is nothing down there for RVers to enjoy. We worry about security with our business. The veterinary industry tends to be a high target for vandalism and for break-ins and thefts because of the medications that we carry. So what this business will impose by moving in is the fact that the rest of us will have to spend significant amounts of money to increase security, potentially hire security personnel to help our staff feel safe. The other problem I find with this is that with us not accepting new clients, we have the potential for 67 angry people at our doorstep every day if they all have pets. Most do. But if they do, and we're not able to see them, and we have to send them and their RV to Ridgefield or Vancouver or Longview for care, the impact that has on myself to be the one to have to talk to them or our staff is going to be extremely detrimental. Is my 3 minutes up? Okay, thank you.
Thank you. Is there anyone else in the gallery, party of record, this evening? Yes.
I believe Dr. Sullivan is.
Yeah, go ahead.
Hello everyone, my name is Dr. Roberta Hemmelman. I'm a chiropractor on Belmont Loop. I have been on Belmont Loop for 9 years, and I just recently built a $1.3 million building at the corner of Old Pacific Highway and Belmont Loop. Had I known that this was a potential, I may have I would have chose a different location for my brand new beautiful building. As Mary stated, we are booked out quite a bit for both chiropractic and massage, and we do have people walk in all the time already, and they get very, very irate. What do you mean you can't see me today? I'm traveling through on vacation. You have to see me. And it's like, sorry, I can't. So having a permanent commercial building with permanent employees would be much more compatible, not only with my business, but the ones around us, because those are people that are in Woodland long-term. It's not, oh, I'm here, I'm gone, I'm here, I'm gone, I'm here, I'm gone. Doing a new patient exam actually takes significant time, and then, so that turnover is not a benefit. And so I do worry about my property values going down. I do worry that I have taken on, again, I think my building is fantastic, but I put a lot of money into it. I am a huge supporter of the Woodland School District, community, all of that, and I feel it is Woodland's duty to help support the local businesses as well. Thank you.
Thank you. Dr. Jeff?
Yes, hi. My name is Dr. Jeff Sullivan. I live in Woodland. I wanted to talk about crime issue, and I know Mr. Turner mentioned statistics or lack thereof, and I would tend to argue against that position. In an article titled Crime in RV Trailers, this article speaks to, in national parks in 2018, and national parks including RV parks, crimes against persons were 57% of the crimes, 19% were property crimes, crimes against society were 10%. Now what's interesting is that drug crimes were only 3% in this particular data gathering by the National Park Service. I would argue that that number is going to rise appreciatively, very significantly, because this was 2018 when this study was done. So drug use is higher now, and of course, that's going to drive a lot of this crime that's going to happen at this particular RV park. In an article from the Columbian in 2019, June 16th, 2019, it speaks to, it's titled, "As Housing Costs Climb, Living in an RV Park is Affordable If Technically Illegal." And the article speaks to how people are beginning to find that it's a lot cheaper to rent at an RV park. And here's an example. They tell you monthly rent at the Van Mall RV Park is $430 for a month. And the average rent for a one-bedroom apartment in Clark County is $1,234. So the article goes on to say that people are looking for low-income housing solutions, and RV parks such as this will serve that purpose. Now, with all of that said, I would like to add a few other comments regarding what true RV parks advertise as. And here's one. Concully State Park says that it's a 97-acre camping park with 5,400 feet of freshwater shoreline. The next one is Anderson's RV Park on the ocean. It is only about a 30-second walk from the beach. The next one down is Westgate Cabins and RV Park, close to a popular beach for clam digging and horseshoe throwing. Less than hookups with a quarter of them offering ocean views. Yesterday's RV Park, only a 2-minute walk to the beach. So you get what I'm trying to say here. I'm trying to understand how this could be an RV park. Who is going to come here to recreate? There is nothing to visit. There's nothing close by you can walk to. The way I could see this owner advertising this RV park as an RV park that is just a 5-minute walk to exit 22 of I-5. So what we're going to see is a whole host of people searching for an affordable place to live. Now, if this is all about low-income housing, then let's address that.
Doctor, your time is up. I hate to cut you off. I'm sorry.
That's all good. Thank you for your time, folks.
Thank you. Is there anyone else online at this time? That was it? That's a party of record. Is there anyone else in the gallery as a party of record? Seeing none. All right, we will allot 20 minutes to the applicant's, let me make sure I get this right, the applicant rebuttal. You have 20 minutes.
Thank you, sir.
All right.
I appreciate the position that both the residents of Woodland and that the City Council is in today. There are fears and opinions that have been shared both in the initial proceeding and here tonight. And unfortunately, what I hear is that it's the contents of the municipal code that the appellants are truly taking issue with and not my client's application. The City of Woodland operates pursuant to a code that sets forth how property can be used and how it can be enjoyed. The code at section 1736030 includes a specific list of conditional uses for which property located in a highway commercial district, or C2 as you know it, may be used. This list does include other businesses who appear on this record tonight. And in the same vein, the list includes recreational vehicle camper parks. Under Washington law, property owners who file an application for a permit are entitled to a decision that is neither arbitrary nor capricious. According to the Washington Supreme Court, the imposition of conditions on the grant of a use permit requires the city to specifically describe the adverse issues and then to either outline mitigation measures or to specifically state why such measures cannot be achieved. Here, Mr. Turner, the hearing examiner, acted consistent with Washington law in methodically examining the facts necessary to ensure compliance with the criteria to grant. Mr. Turner outlined the mitigation measures, and the applicant has been receptive to every condition placed on it. The applicant revised its site plan to meet the open space requirements, to increase curb appeal, and to add commercial use abutting Belmont Loop. Most importantly, the applicant proposed and will enforce park rules and regulations, or CC&Rs, that will be imposed to ensure the park is of the highest caliber and attracts guests meeting or exceeding that threshold. We heard a lot of opinions tonight, but what neither the examiner, Mr. Turner, nor this council have been presented with are studies, statistics, or experts backing the personal concerns and opinions raised in the original proceedings and rehashed here tonight. You heard Mr. Turner say in his original 15 minutes that he was presented with no evidence. Unfortunately, opinions just don't rise to the level required by the courts. Under the circumstances before him, the examiner made the correct decision in approving the application. How do we know this? We know this because two land use decisions, based on opinions rather than facts, made their way up to the Washington Supreme Court. Neither case ended favorably for the local governments involved. In the 1988 case of Cougar Mountain Association versus King County, the county denied a developer's land use application, citing significant impact on the environment. After 6 years of costly litigation, the land use denial was reversed because the county's determination was conclusory. And that's a word I'm going to use a lot through the rest of my time here tonight, is conclusory, which is the same as opinion-based. We have a conclusion, we have nothing to support it, we have no evidence on the record. There, the county's determination was conclusory and did not indicate how the proposed use conflicted with the environmental policies or how the shortcomings could be addressed. In 1997, a similar case, which is Hayes versus the City of Seattle, made its way up to the Supreme Court based on a land use denial where the city denied a project because it was too big, apparently on the theory that smaller would be better. In awarding monetary damages to the developer, the Supreme Court found that the city's denial was arbitrary and capricious, which they defined in part as the following: willful and unreasoning action taken without regard to or consideration of the facts. What we can take from these cases is that although the applicant bears the burden of proof, they also get the benefit of the doubt where the use is conditionally provided for and all conditions can be met. Here, the action encouraged by the appellants falls in line with the conclusory or arbitrary and capricious decisions overturned by the Supreme Court in the Cougar Mountain case and in the Hayes case. While every citizen has a right to disagree with the process and its findings, filing an appeal based on conclusory opinions is not enough to overturn the solid and well-reasoned approval issued by the hearing examiner on this application. In approving Belmont Loop's application, the hearing examiner was satisfied that the use of the land was not only provided for by the code, which it is, but that the conditions of approval can be met. So I'm going to address the 5 issues that we agreed upon for appeal. And I'm going to ask you to keep in mind, as I do, the distinction between conclusory opinions and factual findings from a legal perspective, and then I'll address now the issues on appeal. So the first issue raised on appeal was the public welfare argument, alleging the police chief's comments were misinterpreted. I would encourage the city council to read the email for themselves. I know that it's in the record. There are accusations that it's been misrepresented, and in fact tonight when the appellant made their first presentation to this council, it was again misrepresented. So it's a piece of paper that speaks for itself. I don't think you need it interpreted for you. The police chief was asked to speak to the specific issues of crime with the only other RV park in town, and he said that although there's been an uptick in thefts involving vehicle components, which of course could not be the result of our park, which doesn't yet exist, most of the business owners have have upgraded or improved their systems. He went on to say the city has one RV park in the limits and there does not seem to be any significant increase in call volume or criminal activity there. It speaks for itself. Unfortunately, on this record, the only evidence we do have is from the police chief, who tells you that there has not been an increase in calls or criminal activity as a result of the RV park that is here in town already. The next thing I sort of want to speak to for a second, because I think it's been a point of contention through the appeal, is statistics with regards to RV parks. The RV industry is a huge industry in the United States. It contributes over $115 billion to the U.S. economy every year. Washington and Oregon alone account for over $300 million in RV sales. And the majority of RV owners, baby boomers. These are people in their 50s, married, with annual U.S. household incomes in excess of $70,000. These are not drug-addled, crime-addled, theft-ridden people. These are baby boomers who are enjoying their retirement, who are traveling from park to park, from state to state, and enjoying the parks available to them. The other distinction I would make was between a recreational vehicle camper park, which is what the City of Woodland provides for, and a trailer park. A recreational vehicle camper park is a place where people with recreational vehicles stay for a limited period of time in an allotted space or site. A trailer park is a temporary or permanent area for stationary mobile homes, which are stereotypically viewed as lower income housing. That is not what's going in here. And for any of us who have traveled to the Clark County Fairgrounds RV Park, you'll have a very good idea of what this is going to look like. You could travel right past that park and never know it's there because it's clean, it's neat, it's attractive, it has expensive vehicles, and it has short-term guests enjoying the facility. The next argument that I'm going to address on appeal is the public welfare argument with regards to the city's inability to perform code enforcement. I think Mr. Turner made reference to a Court of Appeals case based on hypotheticals that was overturned because the City Council cannot base its opinion on hypotheticals. The city's ability or inability to address hypothetical violations that have yet to occur would fall under the category of conclusory issues reversible on appeal. The city has been confronted with no facts evidencing a higher rate of code violations in RV parks than any other use in a highway commercial district. To the contrary, the arguments offered on appeal are hypothetical situations that contradict basic economic concepts. As we know, the better maintained and attractive a park, the more the owners can charge and the higher caliber of guests they will attract. Less qualified guests bring issues with non-payment, conflicts with neighboring guests, and drive up the cost of administration. The applicant here, as Mr. Turner recognized, or perhaps it was Mr. Goddard, is investing a substantial amount of money in this project and has an economic incentive to maintain high standards as approved in its application. As to the safety and welfare impacts on the community that were raised in the appeal, I previously addressed these, but I'll remind this council that those are, in the eyes of the law, both baseless and conclusory arguments because you've been provided with no evidence that this park will increase the amount of crime in the area. The next argument with regards to public welfare is the safety impacts to neighboring businesses and properties based on compatibility and conditional use standards. Here, I believe the appellate conflates several separate code sections in making their argument. The appellant first argues that the city has an obligation to protect property values, and next that the approval of an RV park becomes a moral issue where negative financial and safety impacts might result. The appellant references only Woodland Municipal Code 1772-050, which, as Mr. Turner mentioned to you, says nothing about property values. It is not this council's obligation nor the hearing examiner's obligation to protect property values. It's actually 1736-130, which is the architectural and site design standards that makes reference to property values, and that was not an issue raised in this appeal. Instead, 1772-050 caused the hearing examiner to consider whether a proposed conditional use will be materially detrimental to the public welfare or injurious to the property. And as you've heard today, there's been no evidence that that will be the case. The use to which this property is being put is one that's expressly provided for in your code. So to the extent that the appellants here today claim that they could never have seen this coming, then they should have reviewed the code for the space next to them or for the remaining open spaces in this area, because this code provides for this express use. Woodland Municipal Code, I'm in the wrong jurisdiction today, 1736-030 enumerates 12 conditional uses. The third item on the list is RV camper parks located east of I-5. In the law, we call this per se. Per se means the thing speaks for itself. Again, the appellant's argument does not succeed where property values are not at issue and where the proposed conditional use is one expressly intended for this space in this district on this east side of the highway. Next, we go into compatibility, and Mr. Turner presented the argument that I had here on appeal tonight. Without citing to any particular code section, it's hard to follow the basis for this portion of the appeal or how it differs from arguments 3 and 5. As the city made clear in its approval, there is no highest and best use requirement in the relevant code sections. The term used in the code is compatible, which regards traffic, which references the site conditions and not the appeal of the property to the neighboring business owners. To that end, the code requires that all measures be taken to minimize possible adverse impacts which the proposed use may have on the area. Here, compatibility was covered, and we know the use is compatible because the code expressly provides for it. All measures have been taken to minimize the adverse impact to the area, and the applicant has agreed to every single plan revision put upon it. It drafted park rules and regulations and is pouring plenty of money into the development in order to create a space and a profitable business that attracts desirable travelers. Again, I'll make reference to the Clark County Fairgrounds, which is in the vision of exactly what this will look like. It sits amongst commercial and residential land uses, and I would encourage you to look at those, the surrounding properties in the Clark County Fairgrounds area, which have not suffered from the construction of that site. And while property values are not at issue here, if you did a study of the property values in the area, they have continued to increase along with all of the other property in Clark County. As for the two remaining assertions, the city has been provided with no evidence of negative financial or criminal impact on the surrounding business, nor any evidence showing a materially detrimental impact on the community under 1772-050. The claims made in this appeal are conclusory, which according to the Washington Supreme Court are insufficient to impact a land use decision. Prohibiting the free use of real property based on unsupported fears would be legally inappropriate and unsustainable on appeal. The last thing that I would like to address is the final issue on appeal, which is the city's ability to apply a very good condition visually and mechanically standard to RVs in the park. It is not this city's job to ensure that every business uses its real property to the best of its commercial ability. That's capitalism. That's what capitalism is intended to do. As we've discussed, there are easier ways of making money, but these owners are invested in this project and will be invested in the community because it behooves them to do so. It would make no sense to go through this process to spend the money in developing. We heard about another owner today who's put an extensive amount of money into plans. This developer's done the very same thing. They've hired an attorney and they're investing the money in this community. It would make no sense for them to do so and have this park shut down a year later when they don't comply with the uses. With attractive facilities, well-maintained RVs, and a safe and secure community, the applicant will boost the financial success of the park, which will infuse some of that $115 billion in RV industry money into this local community. There are restaurants on the loop, there are service stations, there are automotive repair stations, and of course there's the greater Clark County community, which will benefit from the influx of this business and these visitors. I urge the council to make a decision consistent with Washington law and consistent with its own code. I understand that there's distaste over the express approvals in the code for what's intended for a Highway C2 conditional use area, but this is one of those express purposes. The applicant has done everything that's asked of them, and the Supreme Court tells us that that is the process. We can't tell people how to use their land. What we can do is we can give them the conditions for usage, and if they're not meeting those conditions, then we can make a different decision. But here the applicant has agreed to every condition put on it, and the use is consistent with your code, so I would encourage you to uphold Mr. Turner's decision on the approval of this application and allow this park to benefit your community. Thank you.
Thank you. The time is 8:25. At this time, we'll take a 10-minute recess. And if everyone, to include council, to not discuss anything that's been brought forward this evening, and please don't approach council to discuss that. If you want to ask how the weekend was, that's different, but please keep the topic high level and not to what we're speaking to this evening. So it's 8:25. We'll go back into session at 8:35.
This conference is no longer being recorded.
And then, yeah, so then there's the curtains, and then like nobody wants to watch them. It's too cold. But we had, so we took like a couple years worth of grant fundraising, and the donor compiled it, bought that, overhauled the walking cooler with newer candles, the things that make it cold, and then they just sterilized it. So it's like a whole I'm excited. Now, so we're thinking that next one so maybe that's a good time to have
So how's your little guy like
this? You have like cracks where a gentleman brown goes out. But now you kind of still green to one side. So we thought maybe that's the next project. 120 something year old building. You're right. Thank you. Good inside. I know.
Sure gives you a little bit of an upper hand.
You know, like the golf tournament's a good one.
Oh, yeah, right.
We've been very fortunate.
But you're not doing that anymore.
No. Or are you? Not, we didn't last year because of COVID. This year, it didn't seem like enough time not knowing what. So maybe next year. Youth football. I think next year's our option. Yeah, it doesn't seem like.
Because Rotary can, and then so is a chamber, but it's not shotgun start. It has to be 10 times.
Yeah.
Every 8 minutes. You know.
I kind of
Either you've got to have a hamburger at the time or a hot dog or a box sandwich. You can't. It's fun things. It's tough. It's kind of tough for a fundraiser, right?
Well, you know, give them the opportunity.
We sell a lot of tickets for items that have been
And then you'll know.
You know, we
You tell how they act.
Yeah, the rappers.
Yeah.
That's always a good try. Good job.
So 2 years ago, I found out they were discontinuing one of my garment was discontinued.
Well, you're a mean son of a gun.
So I ordered it for our next golf
For a
tournament.
kid?
It's
Yeah, I feel
still
sorry
in the
for
box.
them.
Upstairs in my building.
Yeah.
Hey, that's a good one.
It is, yeah.
They had, another one.
Well, but they'll still know if you give them the opportunity, you know, to try something, see how they gotta have the experiences to know what they're gonna be like. And then all of a sudden they'll fall into something.
But I think,
You know,
yes, you know.
yeah, and you'll know.
Dollar raffle. Because your guys is the chamber. Which one is first? The chamber or the Rotary?
It's a 25th of this month.
I was gonna say, is he out there smelling the
Good luck
roses?
on the weather.
I know, it's always.
Looking at the bumblebee fly around.
And then Chambers is in August, towards the end of August, yeah.
Well, that should be exciting.
You know,
People are probably
baseball might
raring to
not be
go.
his thing, Dad.
Have an event.
Right.
I'm happy to get back to catchers and pendants. I feel like this whole last year, I feel like all the work that needed to get done in this room about waylaying, like the response to, what do we do with, what do we do with this and how do we handle that? Yeah, so it'll be nice to get that. Someday I'm gonna get to take a tour of the research trailer plant. I've never been in there. I've always wanted to go see what that's about.
I should take my finger and go down.
Well, maybe next spring.
They'll let us into confined space.
Yeah. Right.
I'll go 3 hours. I took a week off that week.
January, June.
They take it the mayor with land somewhere.
Yeah.
They did not replace this.
Yeah.
I did not know they were.
Yeah. When they graduate this year.
That's gonna be a.
Yeah.
Two of them off to college.
Off to college, yeah. And then they've got the one that's a little bit younger, you know. I'm not sure what grade he's in.
Get his parents all the time.
Yeah.
Probably just counting down the days. Yeah, my sister-in-law's son was always playing baseball. The mayor's son. So they were like, so he's put a lot of their pictures of my nephew. It's like, oh.
Did you see the when they were about 3 years old?
Yes,
Yeah, that was
I know.
cute.
That was adorable. That's why I didn't realize they were twins. Yeah, my nephew, he's gonna play baseball.
Vacations.
Oh, is he graduating this year?
Yeah, he transferred to Sullivan from here. So yeah, he graduated this year. He's off to Montana to play baseball, I think. Yeah.
One of my granddaughters played basketball for Titans.
I don't know if that
She went to college up there for 2 years. She finally became a nurse. She just graduated in August of this year.
Yeah, I forgot to ask when he's going to go to school for. My other nephew, good
job.
Computer science, something computer. But he went on he graduated next year maybe, but he went on a track team. He was here.
It's kind of nice if they all go college. She got through college through the nursing program.
Good.
She kind of so she kind of faded. She went in on work. She did good.
It's just, to me, it's sad that kids put so much into bettering themselves by going to school to then start their adult lives in debt. And it's not even like little that it's roughly.
Not there anymore. I got friends and family when I come back to visit. Yeah, I come back to visit.
And then they have that debt and don't know what they want to do to stay up. You know.
I don't know, I'm 50, I'm still not sure what I want to do when I grow up. I'm getting the hang of this grandparent thing, though.
Yeah, okay. It's wonderful to be able to spoil them, send them home. You don't have the responsibility.
Yeah.
Yeah.
My parents always said,
Yep.
oh, candy? Go home.
Yep.
Get them home, buy them a tab on candy and send them home.
I did. Memphis in May. I was serving this once. I got to stand in front of Graceland for about half an hour. I can remember.
Oh, that was what I didn't think of.
Oh, it's so long. Good to go, girl. It's so nice.
Doc retired there, so he's got a house on my own. Mother-in-law, ex-son-in-law, you're interested to see that.
I'd like to go to
I won't miss a council meeting on November 15th. Oh, so we were gonna go to Texas.
It's fun to take
planes there. Because it's Thanksgiving. So my dad's like, it's Thanksgiving anytime. So we were gonna leave on the 13th, and then in November, and then.
Oh, yeah.
And then come back here, so then.
That's what
Oh, that's right. Oh, perfect.
I don't understand.
Yeah, Scott just didn't buy the tickets because he was like, the prices are sure.
So she said they
wanted to get them now, but,
so I was saying, well, it's actually feature back there that you're missing out.
He's an hour between Dallas and Shreveport. But to go from Portland to Dallas, I was like, she was $300 more expensive. So we got creative, and so we went from here to there, and we're gonna hang out there for like 3 days. Yes. Yeah, and so and again, the last time I did that with my dad doesn't stop when I say it's like go from across the border
As fast as you can get back into Germany.
yeah, so
I know Germany, different places. It was cool.
that's when in November, you know,
I was so fascinated.
I'm like,
It'll probably be nice for you. That
exactly.
you know.
I know there's usually a trade show in January for work, and it's in California, and people dress like this when we get there. We leave in like bundled up in a coat, and we get there, and you have to start taking things off, and everybody there's cold. This is like summer.
That's when they go to Hawaii
On the train.
February and March. People
Yeah, and what you see, the ruination,
short
see along
t-shirts.
Yeah.
What the heck? But it's their winter time, you know, so.
And you know, you'll see a town.
Give us just a few more moments here, please.
And then you'll go around and see another one on another.
I'm in shorts and t-shirt. You guys are wearing all white jacket. I'm like, what? It's still summer for me, boys. This is cold. Hello, this is warm. It's still warm, though.
I went to Vegas once with my dad in October, and I was surprised at how hot it is in October.
We went, me and my 3-year-old daughter, it was fascinating, and we were in short sleeve shirts.
Yeah, it was a lot of fun.
And yeah, down in Vegas, it was unusually hot.
Back there, Sunny, we was my house. Chip, give me a thing. Give me a thing. Climb it down. This one that washed it a few hours ago. Holy crap.
Yeah, you have to find a restroom and start stripping. I came back from Costa Rica and then I'm in Chicago. It's like, okay, layering. Yeah, it was significant. Chicago were so nice. I know, like, I want to go back and visit. Everybody in the airport was so nice. It's fascinating.
It's like it everywhere.
Yeah, that was I stood up and broke a pop, so I had to finish.
No, I've read
Oh, we went into a couple of them. They brought like yeah.
Oh, well. Oh, yeah. Listen to the whole meeting. Okay, I apologize for the delay in getting back. We just had to get some clear direction here to run the meeting. The time is now 8:42. Stand by.
This conference will now be recorded.
Travis, did that log out?
Nope, we're back in.
Oh, okay.
I think that's what I was just checking there. No, it's still.
You just gotta jiggle the mouse every so often.
All right, we're back in session as 8:42. I want to remind everyone online and in the gallery that this conversation is now being held by the City Council of Woodland, and all testimony is closed at this time. So I ask that you please keep there will be no more questions. City Council, this is their opportunity to discuss this. So please, no comments or actions from the gallery. All right? City Council. Mr. Fredericks.
So when Ms. Goldfarb made the presentation, is there a follow-up or rebuttal to that? Or is that how?
No, this was the procedure that was outlined.
Got it, okay.
We don't get a voice here to vote?
That was not what was agreed to. Because it's basically you had the presentation, you also had the applicant, and then this was their chance for rebuttal.
Mr. Plaza?
I'll go ahead and start since nobody else wants to jump up. I've got a few questions for whoever it is that answers them. A few for you specifically, obviously. So just to get started, on page 31 of the packet that we got, I'm kind of a stickler to some stuff, so this seems kind of anal, for lack of a better word, forgive me. But under number 7, under 7A, the question is asked, are there any environmental health hazards, including exposure to toxic chemicals, risk of fire and explosion, spill, and hazardous waste that could occur as a result of this proposal? If so, described. And they listed none anticipated, but in an RV park, wouldn't you have propane, gas, oil, and potentially the potential for human waste spillage?
And I'm not sure what document you're referencing, unfortunately.
I only kept the pages that I had questions to.
I think
so
he's
didn't get-
referring to the SEPA checklist.
Probably.
The SEPA environmental checklist, and I'm wondering if that's prior.
Yeah, it is the SEPA checklist.
I don't think it's looking into the future, though. I think it's talking about,
But I didn't
are
see
there any
anything that-
prior environmental health
I didn't
hazards?
see anything that addressed that in the later papers either, that's why. I'm kind of curious.
Mr. Goddard would probably be able to clarify that.
No, if you can answer it now, that'd be great.
So your specific question was?
Okay, so on the paperwork, and the only one that I saw, so if there's others and that I missed, forgive me, but as far as hazardous waste or dangerous stuff, they put none anticipated, but I'm assuming because it's an RV park that we're going to have propane, gas, oil, the potential possibly for human waste spillage, through their hoses or whatever. And I was just curious why that wasn't listed, if those are actually issues.
So those would be a typical impact that could occur at a normal use, just whether it was a McDonald's or something else. The SEPA environmental checklist is theoretically designed to look for significant adverse environmental impacts which warrant mitigation or warrant identification. So a business will typically have something like a spill prevention plan or internal operating procedures that would address how spills like those are handled. In this case, each one of the sites will have a sewer hookup.
Right.
So the assumption is that there shouldn't be a lot of spills.
Well,
and
yeah.
ones that do occur are probably not typical.
Okay. Okay, because the reason why that kind of tipped my hat a little bit, because under number 5, it says proposed measures to reduce or control environmental health hazards. They have none. So I'm assuming that they've taken these things into account, and so that's what I'm kind of finding out. So what steps are they going to take to address these things, because it's not listed on the thing?
So that's pretty typical. Typically, things like the installation of individual sewer hookups are one of the measures that they would take to prevent full and overflowing storage tanks and leakage.
Okay. And as far as the potential for, to go worst case scenario here, because it does say risk of fire and explosion, what's the plan for if a propane tank explodes or gas catches on fire or oils or whatever? Do we just call the fire department and sit back and hope they show up quickly?
Yes.
Okay.
So that's not a land use related issue.
Okay, so everything that we have to talk about here tonight, it has to have to do with just the land.
Generally, yes.
Well, it should. Let's take care of all my questions then.
So
Mrs. Rhodes?
our responsibility to the businesses that's already there does not relate to this, is that correct?
Well, I shouldn't say that that is an absolute, because this is a conditional use permit, and the conditional use permit is for uses that are, and I wrote this down because I figured this would come up, unusual or unique types of land uses which, due to their nature, require special consideration for their impact on the neighborhood and land uses in the vicinity. So the issue of propane tanks, that's consistent throughout the community, and it's not necessarily associated with this specific use, because
No, I get that, but the reason why I was asking is because down below, well, first of all, because they didn't have any of that listed, and then second, because under what measures do you have to reduce or control those hazards, they had none, and so I was trying to clarify to find out what those were.
so the applicant might be able to answer that better, but typically that's a pretty standard answer because there is not typically enough of a hazard that it warrants special treatment. Now, if this was something like an air gas or some kind of gas generator, they would have spill prevention programs and safety programs would be warranted. But like gas stations, for example, they have spill prevention kits and those things at each pump. And they have a procedure to follow if there's gasoline spilling in the gas station. So in this case, it's not something that would warrant an environmental impact statement.
Okay.
I don't think Mrs. Round's question was
No, it
answered.
was never
So
answered.
I just, no, it's fine, because so if we were to take the dog food plant that is over in the Port District and pop it down in the middle of a neighborhood, it was going to be built there in maybe an apartment complex is right next door. Is that should be a consideration when council is, I think it's kind of what Mrs. Rounds is getting to. What exactly is the responsibility to the folks that are already here versus what's coming?
It can be considered because it falls under that kind of conditional use thing to consider. However, the examiner and the applicant both pointed out that there needs to be sufficient evidence for you to reach a decision. Theoretically, that's one of the bars you need to consider. And Frank would be able to expand on that because that needs it. But at the same time, the consistency with the comprehensive plan theoretically can be something that you can include. The question is, are you confident enough that it is a defensible position? Is one that you would have to take into account.
Mr. Potts?
Just one more clarifying question for myself, because I'm old and I don't know everything. If we're only allowed to stick our questions to land use, how are we supposed to get any facts that will help us come to a decision on whether or not to continue with this?
So theoretically, all of the information should be in the record that you were presented.
Right.
And if it doesn't answer your questions, then theoretically you would want to remand it to the hearings examiner with some specific questions and give the applicant and the appellants the opportunity to present arguments and to make the argument for the hearings examiner.
Okay, so now I'm getting confused. So we can ask questions about anything that's in the packet that we got. But I'm not trying to put you on the spot, I'm just trying to clear it up for myself. So we can ask about anything that's in the packet, but I was just told that we had to keep our questions specific to land use. So I'm trying to find out which way do I go?
Well, theoretically, everything in the packet has to do with the land use application that is before you.
Okay. So if noises, impact on businesses, all that is all good to ask about?
Yes.
Thank you. Okay.
Yes.
I'm going to take a breath so I can get my stuff back together if somebody else wants to go.
Mr. Fredericks?
Yes. Mr. Goddard, can you think of a legal claim? I'm not trying to put you on the spot here. A legal, hypothetically speaking, if this council were to agree with the appeal, legally, where would we stand on the legal claim if it was based upon the fact that you could make an argument here that for every time it's saying, oh, the comprehensive plan, this is consistent with your comprehensive plan, I am sure I could go through the comprehensive plan and find that this use is not consistent and make an argument for that. Is that strong enough to stand? Because going back to Mrs. Goldfarb's statement, I tend to agree with her that a lot of this is based upon hypotheticals. It is based upon conclusory evidence, easy for me to say. I believe it is consistent with state law. It's consistent with the use. I do have very strong feelings, I underline the word feelings, and opinions that are very consistent with the appellants in this case. But when I take that all back, I come to the conclusion of, did Mr. Turner go above and beyond here? Did he not follow what he was supposed to do in this case? And I'm finding it very difficult to ensure that when I make a decision on this, if I make a decision to agree that Mr. Turner acted in error in his decision here, it concerns me that I don't have a leg to stand on when this goes beyond here. And that I guess is my concern. I'm also concerned with a lot of the crime issues. I mean, we've had a considerable number of catalytic converter thefts, vehicle thefts lately. That's all over, well, it happens to be all over the Ninth Circuit Court, which is based in California, that covers this state. And I guess from that point, I guess I would say federal elections have consequences, because if you travel outside of this circuit, you won't see what you see in this circuit, which is tent city, homeless trailers, crime through the roof for the most part. There are other pockets of it in other large cities. But that's my concern at this point, is I am not confident enough that our comprehensive plan is sufficient here in this case to deny this or to approve this appeal, and that's what concerns me. So if you were someone who was on this board who again, the word feeling, or has the opinion of that this is not a good use for this area, could you make a legal case for that?
I'm not an attorney, but...
Did you stay at a Holiday Inn Express last night?
Yes. Our comprehensive plan includes policies and goals that are aspirational, and some of them are at odds with each other. And so if you feel that there was an error in the examiner's conclusion, you could theoretically reach findings if you felt there was evidence in the record that made you confident enough, and a majority of the council confident enough that the appeal could be upheld and that the examiner erred. You could theoretically create that argument. But you would have to base it upon evidence in the record, and does it get you to that majority of the council feeling that there was an error made by the examiner?
Well, to me, it's not compatible with the area, so I find that as one error right there. So.
May I follow up with her question? And the follow-up to that question is that enough to approve the appeal?
For her, it's enough. Is it defensible in court?
If 4 people agree with her.
Is ultimately the question.
Right.
Okay, I think this kind of bleeds into the same two things as them. So you can have two businesses that are incompatible, right? You can have a Catholic church on one side of the street and an abortion clinic on the other side of the street. They may both be allowed by the plan, the city planning, but obviously they're not compatible, right? So I know we're getting kind of into maybe some legal mumbo jumbo here. But from what I saw, and I could be wrong, but from what I saw from the examiner's conclusions, is he was using the Webster's Dictionary definition of compatible. Now, if you have a whole slew of different businesses, mostly you got a pet clinic, veterinarian office, you got a chiropractor's office, loss prevention office, real estate office, what else is down there? Driver's license office, a bunch of other stuff. And you have, that are basically pretty, I think they're pretty symbiotic, you know, they do their thing. Whereas an RV park, people, as was noted before, people come in, they hang out, they party, or baby boomers, maybe their kids party, I don't know. But they hang out for a couple of weeks and then they're gone. They're not bringing business to a real estate place. They're not bringing business to a loss prevention place. They can't use the veterinarian clinic because they're already overwhelmed. People in Woodland can't even use them. The kids aren't going to go to the daycare there. So, again, this might be getting into the legal brass tacks here, but how is that compatible? Just because they're allowed on the property, and you know, doesn't mean automatically that it's a compatible business. Would we be having this conversation if somebody wanted to put a strip club there?
It's not allowed in that zone.
Oh, thank you. Okay.
It's allowed in our industrial zone, Mr. Plaza.
Okay, good.
And I think this is specifically one of the issues that was raised in the appeal, the compatibility question. And this, I think, is where Ms. Brown's comments would become relevant. And that is, she does not believe it is compatible. The examiner may or may not have made a legal conclusion that is sound, but your role as the legislators and the policymakers for the city, you can interpret that the examiner erred and he applied the wrong interpretation of what you consider compatible. That is within your rights. Is it legally defensible if it were to go to court? Could it be held up? I don't know, because the judge will have to take into both case law and the opinion of the policymakers who wrote that. And I don't know the answer to that question. It is within your right to say that he erred because you do not believe it's incompatible. Does that meet the legal standard for incompatibility? I don't know.
Well, I'm not saying anybody erred anywhere. I'm just trying to find out how it's compatible with the rest of the businesses that are down there. Maybe Mrs. Goldfarb can bring me up to speed on that, because I saw some stuff in the paperwork that said it's compatible because it brings in, theoretically it brings in businesses. The people that use the RV park will use, most of the businesses that are down there. But that doesn't really tell me a whole lot, what businesses exactly will benefit from the RV park going in there, other than the fast food places and maybe the gas stations, because I don't see how the other businesses will benefit.
Mr. Randolph?
What I just want to say is, I'm listening to the comments, and three things that were raised by the appellant is, which maybe touched upon, is a public welfare argument regarding the city's ability to perform code enforcement, a public welfare argument regarding safety impacts to neighboring businesses and properties relating to compatibility and conditional use, and a public welfare argument regarding the compatibility of an RV park with the neighborhood. Those are three issues that were raised, and what they're saying is that the hearing examiner did not resolve those issues. So part of the thing is you can say no on that basis, or you could also narrow it down to what the hearing examiner says, saying these are our concerns, because it is a compatible use in that area by our code. But you have to but it's not an unconditional use, it is something you have to consider. So what I'm hearing you say, and I'm not trying to tilt anybody, but if you're satisfied that some of the issues raised are not an issue to you, there's 1, 2, 3 issues that you're concerned about, you can agree that it wasn't proved and send it back to the hearing examiner.
Mrs. Rams?
What does our code say about in the C2 for jobs? What kind of jobs does this bring into the community?
So our C2 zoning doesn't include anything. That's in our comprehensive plan.
Okay.
Our comprehensive plan projects 20 20 jobs per acre in the commercial designation. Industrial designation is 4 jobs per acre.
Mr. Smith?
It's a 3-acre site, so according to our comp plan, it should have 60 jobs.
That's our aspiration, yes.
Right.
Now, is that something that we can take into account of this?
So, this was another argument raised by the appeal, and that is, and the applicant or the examiner addressed this, and that is typically in planning you have aspirational goals, which are general, and they are implemented by policies and regulations that are specific. And so therefore, we defer to the specific code sections because they implement the aspirational goals. And it's generally not defensible to ignore specific regulations that implement generic policies by interpreting general policies specifically. So in other words, the 10,000-foot level policy of encouraging economic development, and it's implemented by the zoning, and then to argue that this zoning doesn't work because it's not economically advantageous. So it's kind of, normally the zoning is the primary reliance on decision making, on aspirational comprehensive plan. That's why a lot of the codes specifically say it has to be consistent with the comprehensive plan, but you need to meet the code criteria.
Mrs. Graham?
Is it proper to comment and address the criminal activity situation that everybody is coming up with crime?
It needs to be a rational basis. I mean, it cannot be an irrational fear that's driving the decision. So if there is evidence that there is a criminal problem, then that needs to be addressed.
Well, I kind of think it does, but stop me if I'm not going down the right trail. Being that it sits on the I-5 corridor, I've lived in this community where that was an issue many years ago when everything started to develop along the corridor, that it's an easy in, easy off, easy in, easy out way to address that.
Again, you had a very experienced and very capable hearing examiner feeling that it was addressed. He could still be wrong, and if you have concerns, you need to address them. And so,
I do have a concern with that, with specifically this part anyway.
Yeah.
So
But do you see where I'm going?
No, I get what
as
you're
far-
saying. I get what you're saying. But my question, not to, go ahead and finish.
No, well, yeah, no, that's okay.
Okay.
But, so in that respect, my concern would be that with an RV park, if things are open and you have all these people and people can be really sneaky, they're in and off the freeway. And then my concern would be, here you have these folks that have these thousands of dollars worth of money into their buildings. Oh, they aren't open, let's go crack this window. And I feel that maybe there is a potential of a draw of people that like to go and do those types of things and then go into, it would be a draw, then they would address other buildings in the loop.
but part of the law is at some point the decision was made that was a permitted use subject to conditions, and that's what the current condition is. But again, if you feel that the hearing examiner misapplied the law, which certainly could happen, and that's what you're deciding to do, you could send those issues back.
Can I go?
Mr. Plaza?
Okay, so as far as that part, this part of the thing goes, the concern I have with what the hearing examiner used was that, according to the chief of police, there wasn't a significant increase in crime at the RV park on the other side of town, right? Okay. The first issue I've got is a significant increase in crime compared to what? You know, was it compared to the previous year at the park, or was it over the last 5 years? And compared to which neighborhood? Having, you know, worked in law enforcement for 20 years with 8 of them here, I do know that there is crime, not all the time, but occasionally out of that RV park. Is it significant? I don't know. What's the definition of significant? I mean, do we have to have 5 murders for it to be a significant crime, or 2 carjackings, or, you know, breaking into a car? Significant is extremely subjective, and saying that there's no significant increase in crime without anything to compare it to, I think, is a mistake. So that's, to use her words, that's an opinion. We have no facts as far as where this comes from, other than Chief Kelly saying, thanks for asking if there's been any increase in crime at the RV park. According to our records, we have no significant increase. Does that imply that there has been an increase, it's just not significant, or that there has been no crime at all? I don't know.
But is an offhanded comment by Chief Kelly, whether it's right or correct, is that prove or disprove?
Well, that's what the examiner used to justify his decision in that.
And that would be a decision that you misapplied the law.
Okay.
Mrs. Holland?
So nowhere in here did I see where anybody did like a public records request for crime rates at like Woodland Shores. Isn't that the one that's over by Burgerville? That's the only RV park inside city limits that is referenced, correct? Am I correct on that?
They didn't name it by name, but I think that's the one they're referring to, yeah.
So the one by Burgerville, so nobody did a public records request to indicate that there is a significant amount of crime, or that there wasn't, correct? Okay, that's what, so all of it's hypothetical. Regardless of whether, I mean, anybody could have done a public records request of Woodland Shores address to see how many times Woodland Police went there, right? But nobody did that. So for me, since nobody took the time to do that, I have no evidence that there's going to be an increase or a decrease in crime if an RV park went there. I mean, that's just how I look at it. Because they had a lot of time and money to put into these, 250 pages. But to tell me there's going to be crime when you're already by the exit. So, yeah, people could get off there, but they could also get off the freeway to go to the baseball field. So kind of where I went with this was the conditional use, or if it's complimentary, it made sense to me that somebody would think, oh hey, an RV park would be good here because the Little League field's there and Scott Hill Park would be there, and that would make sense. And so our code says it could be there, right? I mean, I don't know. So anyway, the crime thing, I just kept thinking, why didn't somebody, if crime is such an issue at an RV park, why didn't anybody do a public records request instead of just asking Chief Kelly, so, in an email? I don't know. Whose job would that have been, Mr. Randall?
To respond to it. I mean, part of it is again, it was that basically the hearing examiner that made the decision. I mean, the issue was raised, and the hearing examiner said he believed that it was taken care of. And that's the shoulder that you're looking over right now, and that's your job to look over. If you're satisfied with his answer, or if you're not.
So I'm interpreting whether or not I believe that Chief Kelly said there's not a significant increase in crime there in that one place. Because I would think he would know, right?
That's the problem, that's the problem, is a significant increase compared to what?
Well, I hear all the time that every time this stuff gets brought up, on social media, of course, like the Park Upriver, the ones on the bottoms, and it's lots of crime. So that's what I would base it on, compared to places where the sheriffs and the Woodland Police Department actually go, often and regularly. But it seems like the one over there by the Burgerville's pretty darn quiet. I mean...
No, I can't speak to now, but when I was working, we went there a few times a year. So, I mean, obviously, nobody was being murdered or anything, but they had their share of problems. Is that significant? No, but that's not what we're talking about. The issue that I had wasn't whether or not there's crime. There's the wording that was used, as in there's been no significant increase in crime because of the RV park. And again, you can't compare it without, you can't say there's no significant increase or decrease in anything without giving me something to compare it to.
Correct.
You know, so that's where I'm having a problem with, you know, with that. There's potentials anywhere. Anytime you get a group of people together, you're going to have crime. It could be, you know, petty crime. It could be, you know, silly crime. Be victimless crimes. But anytime you get a group of people together, you're going to have criminal activity. Whether it impacts everybody around them or not, that's another story. However, you can't say that you're going to have a crime-free area. It's in my experience, let me put that out there, it's just not going to happen. You're going to have crime if you have 5 people there.
Sounds like they kind of do. They got people entering their buildings already.
Well, that's already, yeah.
You know,
So, I'm not saying that the people that use the RV park are all criminals, but I'm saying just statistically and historically, anytime you get a group of people together, you're going to have a criminal element involved in it. So, I don't bet, obviously, I mean, it sounds like that's not something we can take into consideration, though. Is that right?
Well, government services, like police services, are part of the environmental checklist of receipt. So it is something that could be considered.
Okay.
So for me, it'd be the potential what's coming off the freeway, not really what is staying in the park so much, is it would be a draw from others to come in and make it more active.
Mr. Smith?
So we could take under consideration of increased medical calls, increased fire calls, increased police calls. You could do all of that.
Yes, because that's a government service covered under CEPA.
So I guess if it's mainly baby boomers, which was stated in here, would there be more of a medical call then at that point to an already taxed area?
So the question is there proof of that in the record? And being familiar with the record, I can tell you that there is no proof one way or the other on that issue.
Mr. Fredericks?
But aren't those opinions? I mean, there could be more crime. There could be an elevation of people who need services. We build homes. People who move into those homes could be elderly. They might require more services. We don't deny it for that, right? I mean, so I guess that's where I get back to on the original is hypotheticals. Hypothetically speaking, because of X, Y, and Z, can we approve the appeal based on hypotheticals? And that to me is that I'm having a difficult time getting over that hurdle.
What are you having a hard time with?
Hypothetically speaking, can we talk about future crime that might occur. Because I'm looking at the conditional uses that are allowed in that area. Veterinary offices are included in that area with outside animal runs. Also, child daycare center. So and I also kind of go back to the point of, here's an individual who owns a piece of property that is trying to improve that piece of property, whether or not you like it or not. I don't necessarily like it. I don't think it's a good choice for that area. But if I'm an individual investor and I own a piece of property, that's the pursuit of happiness. My ability to be able to put in a 3.67 RV park is what I want to do. I want to do that. Now the question can be is, can they live compatible next to each other? And I think that compatibility question has been, there's some question with that, but again, every time I come back to the question of that, it's hypothetical. It's my opinion.
Well, let's go off of what we heard so far tonight. I'm going to play devil's advocate
Go
here
ahead.
if I can. Is that all right? Okay, so we've had, well, going through the letters too, 8 or 9 of the businesses down at Belmont Loop say either they aren't going to go in or else they're leaving if this passes. So to go by what we have in our comp plan as far as what the vision for Woodland is, by allowing one business that will have, going by what we've got here, at the most, 4 employees and a food truck, versus over 100 jobs that will be going away if these people follow through with what they're saying, doesn't that interfere with what we have in our comp plan for what we want the city to do?
It goes back to compatibility.
Exactly, that's what I'm saying. It's not compatible. It's a detriment to the Belmont Loop area because it is going to cost potentially, if, again, or factually, if these people do what they say they're going to do, and I have no doubt any of them, that it's going to cost the city thousands and thousands of dollars in lost revenue, jobs for our citizens, but at least we'll have 3 people in a food truck that can work down there. 4. So.
Mrs. Holland.
I just wanted to clarify on page 230. It indicates that this property, sorry, I can't see. Let's see, section 17, letter B. It's 230?
230?
So effectively, it says the city council adopted ordinance 140.58 on March 2nd, 2020, which prohibits self-storage facilities in all zones in the city. However, a self-storage facility was already approved on the site on March 29th, 2018. Therefore, that approval is vested and the applicant may choose to develop that use on the site until the approval expires. So what that sounds like to me is this RV park is an option, but if you grant the appeal and blah, blah, whatever happens after that, this particular piece of land has already been approved for a storage facility. So it sounds like, if I read that correctly, you're going to have one or the other. Or at least the landowner wants to do one or the other.
Hypothetically, he's got until a certain time to do it. And
Right.
It's not saying that he will do it, but.
No, but it's put in here for that, I think,
Right.
for the express reason.
The way I read it was either we get the RV park or you got a storage place coming.
Right, and again, we're telling somebody who owns property what they can and cannot do in a legal, where it is legally zoned for. So I have a snarky comment about that, is we need to go around 2 pieces of land and get public opinion of what we're okay with. Because people buy land, and land ain't cheap here, but then they can't do anything with it. And so I guess they're expected to keep it empty. I mean, everybody has an opportunity. I just kind of have a problem with that, telling people what they can and cannot do when they legally have a right to follow whatever that zone is, whatever our municipal code says they can do. But then it's like, I don't know. I don't know if I like that idea. And I mean, I didn't dig the fact that y'all approved 150 some odd houses out by my house. But that's what I get. So a big old field gets to have 150 houses out by my house. So.
I'm sure that was us, not the state.
No, this was a couple weeks ago, so.
I don't remember that.
I'm just saying, but that was kind of how I read that, is that the intent is, or it kind of sounded like to me, is that they wanted to have a storage facility, but then council voted against allowing any more inside city limits, and so they plan B'd it with an RV park, which seemed like, I mean.
But they still had the option, even though we prohibited it, because they were approved in 2018. So they didn't just change because it was prohibited anymore, because they still had the option.
So maybe, I mean, I don't want to assume or do some hypothetical, because I don't know who owns the land or what their motives are, but it kind of sounds like that to me, is that you're going to get one or the other, but then it seems like it'll come back again because people won't be happy with the storage facility.
The developer scrapped the plans because the one individual was not successful in that.
Mr. Niagara.
Enjoy your evening, everybody. Good luck with it.
Mr. Fredericks.
Just a legal question. Where does this go potentially after here? Cowlitz Court? Cowlitz?
I mean, I believe what happens is that there's a land use petition act.
Okay.
So if a disappointed side did not like it, then they would appeal to the Cowlitz County Superior Court and the Loop action.
And who defends that case?
I mean, I would assume it would be us, because it would be us that would be granting or not granting.
So if that decision is not acceptable, where does it go after that?
You mean if someone's not happy with what's
Correct.
then you go to the Court of Appeals, and then the Court of Appeals.
If you go to the Court of Appeals, who defends their case there? People are going to be making oral arguments. Presumably, the city would be making an oral argument?
Sure, because it would be in response to, if we made a yes or no decision, then we would have to defend it.
So if I made a decision based upon compatibility being an issue, hypothetically, we would potentially be defending that action on behalf of the city who made the decision, the city council, and in essence, the taxpayers are also going to be funding that little exercise as well. Is that correct?
True, and again, what's going to be looked at is what was the record that you looked at. If you are not satisfied with the record, then it's one way or the other to have. I mean, because basically, what the hearing examiner said is that based on the evidence, which you have seen, he felt that this was that it had been adjusted, but there was not a follow to it. And what I'm hearing is that there's issues about that conclusion. I mean, no one is saying he proved it. He answered it. It is the questions that you're still struggling with.
So the choice here, if I'm not mistaken, is to approve the appeal, deny the appeal, or to remand this back to the planning commission with specific action that,
No.
or to the hearings examiner, I'm sorry, with specific action that we want them to look at.
Well, I mean, yes, because, I mean, you know, some of the issues that were raised, the public welfare argument regarding misinterpretation of the police chief's comments, I mean, that, I mean, again, it's an offhanded comment. So again, if there are parts of it, I mean, you should feel comfortable with your decision, whether it's yes or no. And if you're not comfortable with that, then you have the option of sending it back and directing the hearing examiner of what you feel the evidence did not resolve.
Okay. And then potentially we go through this whole process again?
Correct, but you now have given instructions. You have now expressed your instructions to the hearing examiner, and I'm sure he will tackle it.
So we can specifically say we want to remand these specific sections of his finding back to him to reconsider.
Correct, and that would be better than starting from scratch. Because it sounds, it's not like one of you has one concern and one of you has another concern. It seems like you get back either best use or criminal issues. Those seem to be the two things that have been discussed. Sir.
So if it gets sent back to the hearing examiner, can more evidence be brought to him to make a determination at that point?
He could hold further hearings, right? Travis, he could hold further hearings on those issues.
Yes, and my recommendation would be that you not only, if you're going to go that route, not only to remand it to the hearings examiner with specific items, I would recommend that you remand it with some specific deadlines. So in other words, you could request that the applicant and the appellants submit additional information on this issue within the next 2 weeks, and then the examiner and staff will have 2 weeks to review that, and the hearing will be 4 weeks from today. That way there's additional record that is developed. That record is delivered to the hearings examiner, and the public hearing would consider that additional information that's specifically relevant to that issue. And the reason why that's important is because if you just remand it back to the hearings examiner has an established record. That's the 250 pages that were sent to you. And if it's not in there, the examiner theoretically has no additional information to make that additional decision. So both the applicant and the appellant should have the opportunity to raise the additional information that will address and answer your questions, so that the examiner now has a full picture, full understanding of that issue, so that he can rule on it. Thank you.
Nobody's else got anything else to say, so we do something.
Yeah.
Time to vote.
What?
In order for a vote, we need a motion on the floor.
Well, let's see, maybe I'll try to do it. I guess I would send it back to the hearings examiner for 2 weeks to give the appellant and the other party time to present new evidence specific to compatibility and the crime.
Travis, do you think that 2 weeks is sufficient?
And then
I would agree setting the point, but do you think that they would be able to generate the evidence one way or the other within 2 weeks?
The applicant is here, the appellant is not here. So I can't say for sure whether that's adequate, but it would seem to be a reasonable amount of time.
2 2 weeks to me sounds short. Does it to you?
Yeah, and of course, we have to figure out a schedule for Mr. Turner and when he would be able to hear that hearing. So we can take.
How about 3 weeks then? Does that sound better?
What would you think, Travis, for timeline?
So I threw out there 2 weeks. I don't mean to bias you. So the more time that you give, the better answers you will get. But at a certain point, it's just an unnecessary delay. So,
Okay, I'll amend that to 3 weeks then. And then 3 weeks from that day, what was it we were going to do? Have it come back to us? Was that what it was? So that's a total of 6 weeks.
And the issue is crime and compatibility.
Crime and compatibility.
Now, can we have him include studies from at least 3 or 4 comparable RV parks for the crime study? So we actually have something to compare it to this time?
So we may not be able to find specific studies. So requiring a certain number, but you can require that both parties address where they found the information and try and produce as much evidence as we can.
You can't contact the police departments in those jurisdictions and ask for their...
Point of order.
Mr. Fredericks?
We have a motion that has not been seconded that has been, that we're in the process of discussing, and hypothetically, we're speaking about things or action we want people to take hypothetically if it were to pass. So I think it'd be appropriate to make the motion, have that motion seconded, and then there should be discussion.
I agree with Mr. Fredericks.
I concur.
I'll second it then.
Can the chair please restate the motion, please, so we're clear?
Motion on the floor is to send, to seek further information on compatibility and crime back to the hearings examiner, not to exceed 3 weeks. After that 3 weeks, an additional 3 weeks for staff to present those answers back to council, which would be July 19th, 2021. By Mrs. Rounds and seconded by Mr. Plaza. Mrs. Rounds.
I think I've said everything I need to say, that I just think it's not compatible with the businesses, and I think we have a responsibility to the businesses that we have in our community, and so that's based on my decision.
Mr. Plaza.
Okay, getting back to where I was. Sorry about that. So, as far as the comparables for the RV park crime issue, being hard to get hold of those or whatever, isn't it possible that we can get hold of the police departments in those jurisdictions and do a public records request and get any copies of any police activity pertinent to those locations?
So we could do that footwork. The problem I have is I may not be able to produce 3 studies. I don't know if a crime or a crime rate study is something specific. So I would hate for you to require 3 studies, but we can't get a hold of a professional consultant.
Well, I'm not asking for a study. We don't need to go into all the, brass tacks and, have professionals brought in and, teach us the background of criminal behavior. But if we can get hold of the police department, sheriff's department, state patrol, whoever we need to, in order to find out how many times have the police been called to this Joe's RV park? How many times have police been called to Bob's RV park? And then at least when we would have comparables to say, okay, RV parks do have a significant or have a impact on neighborhood crimes versus no, they don't. And ideally, and I don't even know if this is possible, if we can find an RV park, a newer one, and find out what the crime rate was before the RV park went in and after it went in. So at least then we'd have some statistics to go with the concern.
Mrs. Holland?
What towns? I'm confused, I thought.
Well, we have a 67, we have a request for a 67 spot RV park.
Right, but where are we seeking this the crime stats from?
Oh,
That's where I thought maybe I missed something.
No, you didn't miss anything. It's
Oh,
just,
okay.
it's just finding comparable RV parks, which pull out, look up on the internet, how many RV parks in the area have 67 spots. Find one that's comparable. And then you contact the police departments in that area and ask for information on police calls to that lot.
So in theory, my dad used to be a winter Texan, and he stayed at a RV park about that size in the San Padre Islands, and during one part of the year, that's where spring breakers go. So you've probably seen it on TV. All of Texas converges there. So I imagine the crime rate there for that RV park, because everybody local would beat feet, and then. So I imagine in that situation,
So it's
the
like
crime rate would be exponential. So in my head, I'm thinking. So are we thinking maybe in our area? So the place out on the Columbia River. I wrote its name down.
Stevens Mortgage?
No. That is not an RV park.
Well, yeah,
Let me
obviously,
get
I'm not
started on
asking you to
that
get
one.
stats from a spring break RV park lot.
Well, but that's what
But,
I'm saying
yeah.
is it for Columbia Riverfront RV, which is out on the Columbia? I don't know how many spaces. I'm just trying to figure out what we're doing comparables on. Woodland Shores, which is inside our city limits. It's the only one there. I don't know how many spaces are there.
Not that many.
Isn't there one right off of Columbia?
And that's like
Yeah,
a
that-
retired place.
There's the one,
And they still have criminal activity
Columbia
there.
Riverfront.
Columbia River, that's South Carolina.
We have one up to Lewis, which you were saying is not an RV park.
Stevens
Stevens
Mortgage
Mortgage out on
that is a fish camp. That's not that is not on the level of this type of facility.
Well, I think that's the concern.
I think we're kind of beating a horse a little bit here, more than we need to.
I'm just trying to find out what in the heck we're asking him to go seeking, and what part of town we're seeking information from.
I think we could leave that up to Travis. He's an intelligent man, and I think he can find us RV parks that are comparable to what we're looking at here.
Mrs. Graham?
Being that our lovely city has a huge RV retail facility, I'm sure that somebody could go there and they are going to give you a book or tell you where comparable RV parks are. You guys are making it too complicated is what it is.
Thank you, Janice.
I know I am at times. Thank you.
Mr. Frederick?
Anyway, and find some names of some facilities or see what would be comparable to what they're looking at here and do the phone work. Whomever you have to contact. Don't go to Vacation Island or Trash City down at the river or wherever else you gotta go. They will give you comparable places to survey.
Mr. Fredericks?
Sure. I think we're going to do the same thing all over again, and I think we're going to come to the same conclusion. And I find it kind of funny that we're asking Mr. Goddard to pick comparable RV sites or comparable, hey, we want you to look at this. Now, I don't know anything. Are we going to look at the good ones? And how do we define what good is? Are we going to look at mediocre ones? How do we define what mediocre is? Are we going to use the one by the campgrounds or by the Clark County Fairgrounds? Are we going to use that as a comparable? So I think right there, you shoot yourself in the foot because again, you're making an assumption on something that isn't here yet and comparing it to that. And I think that, again, is a hypothetical. Hypothetically speaking, crime could be bad. Hypothetically speaking, crime could be good. Whatever that is. So I have a difficult time with that. I also have a difficult time with, so the compatibility issue, I think, has been unfortunate. I agree with Ms. Rounds. I agree with Mr. Plaza. But I still can't get over the fact that it's based upon conclusions that we don't know of yet. And we're trying to base a decision on that, and I think it's the wrong way to go. So I'll be voting no on this motion, and I'll save the rest for whether or not this motion passes.
Anything further? All right, motion on the floor is to send this item back to the hearings examiner not to exceed 3 weeks to answer questions on compatibility and crime statistics with comparables, it sounds like. After that, a 3-week staff report time to convene back to council on July 19th, 2021. Councilmember Smith.
Aye.
Councilmember Fredericks.
No.
Councilmember Graham.
Aye.
Councilmember Holland.
No.
Councilmember Rounds.
Aye.
Councilmember Chapman.
No.
Councilmember Plaza.
I pretty much said aye, just so I can get my words in, but, sure, aye.
All right, the motion has passed. This item will be sent back to the hearing examiner and brought back to council on July 19, 2021. We've come to the motion, the part of the meeting for adjournment.
Yes, please. Move to adjourn.
Second?
Moved by Councilmember Frederick, seconded by Councilmember Plaza. All in favor say aye.
Aye.
Anyone opposed? The ayes have it. The time is now 9:47.
This conference is no longer being recorded.
Nice treat. Take care.